Heto nga ho ang pag-uusapan natin ngayon. Wala pong iba kundi si Pangulong Duterte. Bakit nga ho ba hindi ho siya binigyan ng interim release, mga ka-update? Kahit na alam po natin, hindi na ho siya fit to trial. Kasi alam naman po natin, mga ka-update, 80 years old na ang ating former president. Hindi lang ho iyan. Marami na hong tinitake na gamot si Pangulong Duterte. Alam po din natin iyan, mga ka-update. Ang mahirap po kasi dito, kahit na matanda na, sakitin na ang isang tao, pilit ho nilang isinisiksik sa maliit na kulungan. Yan ho ang higante ng Marcos administration matapos niya hong ipalibing ang tatay nitong si Bongbong dyan sa libingan ng mga bayani. Kaya mga di, pakinggan ho natin ang pag-i-explain ni Atty. Neil Abayon ukol kung paano pa nga ba o ano ang hakbang para bigyan ng interim release si Pangulong Duterte. Kaya mga kabdit, kung bago lang ho kayo sa ating channel, isang like, isang share, isang subscribe lamang ho. Malaking tulong na ho yan. Rekta na ho tayo.
Hello! So, papag-usapan po natin yung latest development sa ICC case ni Fprrd, which was the denial po nung appeals chamber din nung interim release request niya. So, this is dated November 28, 2025. Kahapon lang po ito nilabas yung live stream po mismo nung ICC. Ito po pala yung tatlong judges sa appeals chamber. So anyway po, this was live streamed yesterday, November 28, around 5:30 p.m. PH time. So this is from the International Court website. Sa mga gusto po mag-verify, pwede nyo po i-visit yung ICC website itself. So in summary po, yung ICC appeals chamber kinonfirm lang yung decision ng pre-trial chamber. So, in other words, yung arguments daw po ni Atty. Kaufman dun sa interim release request is not sufficient para mapagbigyan yung interim release.
Ito mga kabdit, yung marami ho kasi sa ating mga kababayan, may ugong-ugong dun ho na parang ginagamit lang daw ho na si Atty. Kaufman, si Pangulong Duterte. Tingin nyo ho ba totoo ito? Tingin nyo lang ho ba? Kasi wala pa naman ho tayong sapat na ebidensya patungkol dyan. At kasi parang mahina daw etong, alam niyo na ho, pagbibigay ng opinion ni Atty. Kaufman, parang nga hindi maayos ang pagdepensa kay Pangulong Duterte. Marami ho nagsasabi, nagagalit din dito kay Atty. Kaufman na mukhang namemera lang ito. Tingin nyo ho ba ginagawa niya yan o hindi? I-komento nyo naman ho yan para naman po natin mapag-usapan.
Ni Fprrd. So, ang ibig sabihin po niyan, as per the ICC, is that si Fprrd po ay isang flight risk individual. Number 2, he is a individual or an accused who will most likely interfere daw with the proceedings or intimidate witnesses. And number 3, there might be a continuation of alleged crimes kung meron. Yun yung in summary talaga kasi dininay po nila lahat ng grounds na ginamit ni Atty. Kaufman para sana i-grant. Okay, so ngayon po ang gagawin na lang natin, i-discuss ko po sa inyo kung ano ba yung mga pwede pang remedies ni Fprrd moving forward, kung whether or not pwede pa ba talaga siya ma-interim release and any other remedies pa po na meron siya under the Rome Statute. Okay? So good day po my fellow taong bayan, and ang magiging basis lang po ng discussion natin is of course the Rome Statute and the rules of procedure po ng Rome Statute. Okay, so mag-start po muna tayo sa Rome Statute kasi ito yung pinaka-foundation ng mga bagay-bagay when it involves the International Criminal Court or the ICC. So kita nyo naman po, Rome Statute of the International Criminal Court, and then pupunta lang po tayo niyan sa Article 60. So kita nyo naman po dito, Article 60, Initial Proceedings before the Court. And to be specific po, itong number 3 or paragraph 3 yung papagbasehan natin or yung i-discuss ko po talaga sa inyong lahat. So basahin lang po muna natin. The pretrial chamber shall periodically review its ruling on the release or detention of the person and may do so at any time on the request of the prosecutor or the person. So itong person na sinasabi dito is of course ito po yung akusado. Okay, so upon such review, it may modify its ruling as to detention, release or condition of release if it is satisfied that changed circumstances so require. Okay, so kung makikita po ninyo, ang guidelines po talaga ng Rome Statute is that there must be a periodic review of the ruling ng pretrial chamber with regard the detention of the person or yung pag-deny po ng interim release request. Okay? At yung rason po kung bakit pwede ma-reverse or ma-change yung decision ng pretrial chamber is because of a change in circumstance. Okay, so when you say change in circumstance, it must mean na yung change na yon will result to Fprrd no longer being a flight risk. Tapos Fprrd will no longer be a threat to the safety, security of the proceedings or to the intimidation or harassment of witnesses. And number 3, ay hindi na rin magkakaroon ng continued crimes. Okay, so currently po ang sa situation ni Fprrd, yung medyo complicated pa talaga is yung first 2 requirements, which is yung dapat hindi siya maging flight risk at yung dapat nga hindi niya i-harass or guluhin yung proceedings or yung witnesses. Kasi as per the ICC, yung situation kasi ni Fprrd being the elected mayor of Davao City and then him having a very strong support from the Filipino people, dahil daw dun, it poses a risk na magiging flight risk siya pag ipapalabas or i-release po siya via interim release. And then yung pangalawa pa nga po na diniscuss din ng appeals chamber is because of the past history daw ni Fprrd, meron daw siyang tendency talaga na mag-intimidate daw ng witnesses or manggulo ng proceeding. So yun po yung first 2, yung big hurdle or obstacle na kailangan talaga lampasan ni Fprrd, yung flight risk issue niya and yung pang-disrupt or pang-harass ng proceedings or ng witnesses. So ngayon, ang next question na lang po natin, paano kaya yon na hindi na maging flight risk si PRRD or hindi rin siya maging risk na manghaharas or manggugulo ng proceedings at nung witnesses, okay? At kung ako po ang tatanungin ninyo, ang tingin ko pong pinaka malakas na pwede gamiting argument dyan nila Atty. Kaufman, nila Fprrd, is the health situation and the age of Fprrd. Diba? Considering he is 80 years old already. So pag tumatanda naman yung tao, it is logical and reasonable to conclude na habang tumatanda, mas humihina, therefore mas hindi na nakakagalaw ng maayos. So dahil doon, hindi na siya maging flight risk or wala na siyang kapangyarihan mang-intimidate. Yun yung kailangan talaga pukpukin nila Atty. Kaufman ko ako po ang tatanungin ninyo. Unfortunately, ang nangyari po kasi dito sa decision is nakulangan mag-correlate yung arguments dito nila Atty. Kaufman in relation dun sa health reasons to those 2 requirements po ng Rome Statute. Kasi pinasok lang nila Atty. Kaufman yung health issue more on dun sa humanitarian reason eh. Pero yung dilemma dun sa arguments nila Atty. Kaufman, wala pa pong very clear conclusion na talagang mahina na si Fprrd or that he has cognitive impairments kung saan yun nga hindi na po siya magiging flight risk or yung magkakaroon ng strength or power or influence to intimidate the proceedings or the witnesses. Yan po yung isang ground talaga na kung ako tatanungin nga po na pwede ilaban nila Atty. Kaufman. And the only way po for them to do that is to conduct further examination sa health ni Fprrd kasi hindi naman po natin alam, di ba, later on, baka in a span of 3, 6 months or even a year, baka mag-iba pa yung health situation ni Fprrd. So kung magkaroon ng changes, a change in circumstance in the health situation of Fprrd, yun dapat klarong i-correlate nila Atty. Kaufman kung paano yun siya papasok dun sa number 1 at number 2 requirement na hindi na flight risk at hindi na rin mag-i-intimidate or wala ng power po to intimidate or to disrupt the proceedings or witnesses si Fprrd. Yung third, yung continuation of crimes, yun, madali lang naman na yun kasi at the end of the day ngayon, wala naman ng war on drugs, diba? So yung mga alleged crimes na yun ay klarong hindi na talaga magko-continue at present. Okay, so yan po yung first na situation or yung pwedeng mga gawing arguments sila Fprrd, Atty. Kaufman once they request po the review of the denial of interim release decision. Ngayon, ipakita ko rin po sa inyo yung rules of procedure naman ng Rome Statute. So this one po is still with the ICC. So kita nyo naman po yung logo dito and then rules of procedure and evidence. And then yung kailangan lang po natin tingnan dito is Rule 118 of this rules of procedure. So ito po yan, Rule 118, pre-trial detention at the seat of the court. So anyway, punta po tayo doon. And then yung important lang pong iti-take note natin dito is itong number 2. Kasi kung makikita po ninyo, ang nakalagay dito sa paragraph 2, the pretrial chamber shall review its ruling on the release or detention of a person in accordance with Article 60, paragraph 3, which is yung pinakita ko po sa inyo kanina, at least every 120 days and may do so at any time on the request of the person or the prosecutor. So ito lang po is a reinforcement of Article 60 at dito mas specify na at least every 120 days kailangan mag-review ng pre-trial chamber or anytime po, every time mag-request yung person or the prosecutor. So again, the person po is the accused, which is si Fprrd via Attorney Kaufman. So kung makita po nyo dito, every 120 days, kailangan din po yan talaga reviewin ng pre-trial chamber themselves. So yung pre-trial chamber po, yun yung first 3 judges, yung sinasabi nilang kamukha daw nung parang sa Ghost Fighter, yung pinaka-presiding judge or yung head judge ng pre-trial. Yung appeals chamber kasi that is the next level pa na court, which is yun yung kahapon. So ito po yan, ito po yung appeals chamber, yung pinangunahan nito, yung babae na nasa gitna. So hindi po to sila yung magre-review ng every 120 days. Yung pre-trial chamber po, yung mas lower na court, which is yung may blonde nga na kamukha daw nung sa Ghost Fighter, yung pinaka-head. Okay, so yan po ang mga procedures and steps na mangyayari ngayon moving forward sa situation ni Fprrd, considering the appeals chamber has already denied it or has confirmed the decision denying the interim release request of Fprrd. Okay, so again, yung pinaka-important lang po dyan is that mapakita na may change in circumstance talaga sa situation ni Fprrd. So kung yun nga po, let's say may change sa health condition ni Fprrd, yun dapat klarong mapakita at ma-explain yun ni Attorney Kaufman at ma-relate niya dun sa 3 requirements ng Rome Statute for detention, which is yung flight risk nga po, harassment or disturbance of procedures or witnesses, and continuation of alleged crimes committed. And then, ito po, may last lang din akong i-discuss sa inyo na tingin ko posible din po itong argument na gamitin nila Attorney Kaufman. Pero, ang dilemma lang po dito sa next na i-discuss ko sa inyo is that malaki po yung magiging role ng current government ni PBBM dito. So ngayon po, babalik naman tayo sa Rome Statute. Okay, yung last ko po kasi pinakita is the Rules of Procedure. So Rome Statute, and then to be specific po, yung Article 19, yung nandito. So this one po, yung Article 19 is challenge to jurisdiction or admissibility of a case. So yung challenge to jurisdiction ngayon, ito nakapending pa to, di ba? May final ng challenge na ganyan si Attorney Kaufman. Pero ang i-discuss ko po sa inyo is itong admissibility issue of a case. So I have explained this way back pa po nung earlier this year, one of my very first few Fprrd ICC videos. Pero in summary po kasi, when you say admissibility of a case under the Rome Statute, this means whether or not admissible ba ang isang kaso sa ICC, okay? At yung tinitingnan po niya ng ICC is whether or not meron bang kapangyarihan mag-prosecute ang local government or ang local state dun sa alleged international crimes na ginawa ng isang akusado. So kung kaya po nila mag-prosecute tapos they are really willing to prosecute, magkakaroon po ng admissibility issue pag idediretso sa ICC yung korte. So makikita po natin yan dito sa Article 17, yung mga issues of admissibility. So hindi ko na po ito basahin isa-isa para hindi po tayo humaba kasi madami-dami po ito Pero yung pinaka-summary talaga dito is whether or not yung local courts nga po ng isang bansa kung saan meron silang isang akusado who is alleged to have committed or violated yung mga international humanitarian law is whether or not yung local courts na yun is willing, able, and capable to prosecute yung isang akusado na yun. And the reason po kaya ako sinabi na malaking factor dito yung administration ni PBBM or his government is because yung merong pong pinaka-power to make an announcement on whether or not they are willing and able to prosecute an accused who is alleged to have committed or violated international humanitarian laws is of course the Department of Justice. Okay? And the reason kaya po DOJ is because yung mga prosecutors po ng bansa natin is under the Department of Justice. 'Di ba? At alam naman po natin na yung Department of Justice po, the Secretary of the DOJ is an alter ego only of the President. 'Di ba? In other words, si PBBM po talaga yung pinaka-head ng DOJ. 'Di ba? At yung secretary nga po is his alter ego only. Therefore, since sila yung magpo-prosecute the DOJ, si PBBM po talaga in partnership with his Secretary of the Department of Justice ang may power po na magsabi na they are able and willing to prosecute an accused like that of Fprrd. Okay, so yan po yung rason kaya ako nasabi na malaki talaga yung magiging contribution or trabaho ni PBBM kung gusto nila to or para ma-attack po nila Attorney Kaufman at Fprrd yung admissibility issue. So kung maglabas po ng statement na ganon sila PBBM, na they are willing and able to prosecute, tapos biglang sabayan pa ng Supreme Court natin, ng judiciary, na they have the means and the facilities and the venue to properly handle the prosecution of the case ni Fprrd, edi talagang pwede or posible pong pumasok na itong mga issues of admissibility sa ICC, laban po sa ICC. At kung pumasok na nga po yun, hindi na yan pwede ma-admit yung kaso ni Fprrd sa ICC. Okay, so yan po, hopefully mas naintindihan ninyo. Pero of course, ito pong dinidiscuss ko, these are all theoreticals lang naman for legal education kasi alam po natin mahirap na mangyari yon considering the political situation of our country. Very divided po tayo ngayon. And the Duterte family is viewed as the opposition bloc. So kung gawin yun ni PBBM, it is in a way parang tutulungan nila yung opposition. So I'm not sure kung pwede ba talaga or gagawin yun nila PBBM. Pero kung gawin nga po nila yon, that would be a very good argument under dito sa issues of admissibility sa case ni Fprrd. Okay, so hopefully mas na-gets nyo po yan. So ito po, idagdag ko na lang din, additional discussion po to regarding dun sa admissibility issues sa case po ni Fprrd. So balik po muna tayo sa Article 19 and then paragraph 2 po yung ipapakita ko sa inyo. So kung makikita po nyo dito, challenges to the admissibility of a case on the grounds referred to in Article 17 or challenges to jurisdiction, pero ito lang po yung focus na lang natin, may be made by. So kung makita po nyo yung letter A, an accused or a person for whom a warrant of arrest or summons, which is si Fprrd dito, ginagawa nila or ginagawa niya via Attorney Kaufman. Pero sa letter B, kung makita po nyo, a state which has jurisdiction over a case. Diba? On the ground that it is investigating or prosecuting the case or has investigated or prosecuted. So kung makita po ninyo, hindi lang po si Fprrd mismo yung pwede mag-challenge, kundi yung state mismo. And that state po is the Republic of the Philippines na pinamumunuan ni PBBM as the President of the Republic. So even PBBM himself or his administration or government can challenge the admissibility of Fprrd's case in the ICC. So yan po yung best case scenario para may chance na ma-dismiss or mapalabas pa si Fprrd. Pero again, considering the political situation in our country, mukhang malabo pa po pumasok talaga tong letter B na yung state mismo mag-challenge. Okay, and then yung isa pa po na gusto ko lang din i-discuss dito is ito rin pong nasa paragraph 4. Because ang nakalagay dito, the admissibility of a case or the jurisdiction of the court may be challenged only once by any person or state referred to in paragraph 2. The challenge shall take place prior to or at the commencement of the trial. In exceptional circumstances, the court may grant leave for a challenge to be brought more than once or at a time later than commencement of the trial. So, ang point ko lang, kaya ko po ito pinapakita sa inyo because of this one, may be challenged only once. Yan yung general rule. So, dapat talaga pag gawin to ng isang akusado or ng isang state na i-challenge yung admissibility or jurisdiction ng isang ICC case, dapat sigurado talaga sila kasi ang general rule nga po, once lang pwede to gawin. Then next po, pwede naman via exceptional circumstances, may grant leave for another challenge, pero exceptional circumstances lang yun siya. So yung next issue lang po dyan, kung ano ba ang nagko-constitute ng exceptional circumstance sa ICC. And dito po sa bansa natin, exceptional circumstances are very rare situation na very seldom or bihira ang ginagrant ng courts kahit tayo po dito ng local courts. Basta exceptional circumstance yung nire-require. So magiging ganyan din po yan sa ICC more or less. So dapat pag gawin to nila Fprrd or baka ng PBBM admin, they should do it kung saan sureball sila. Or not necessarily sureball naman, pero at least mataas yung chance na mag-grant talaga yung challenge na yun. Otherwise, pag natalo at ma-deny po yung challenge, edi magtutuloy-tuloy na talaga to the trial proper. Okay, so hopefully mas na-gets po ninyo yung situation ngayon ni Fprrd. So kung makita po ninyo at present, natalo si Fprrd dun sa current request niya for interim release, pero it does not mean na final naman po yun, di ba? Kasi pwede pa nga po yan i-review every 120 days ng pre-trial chamber or at any time po pag nag-request yung isang akusado, provided lang po na there is already a change in circumstance of the accused, which in this case po is si Fprrd. And then ito nga po yung pangalawa kong diniscuss, di natin alam, baka biglang magbate si PBBM and si VP Sara or the Duterte family, tapos baka si President Marcos himself biglang i-challenge siya under dito sa paragraph 2 letter B ng Article 19 of the Rome Statute. Okay, so anyway po, hopefully klaro po yan. If you like more legal videos and current events, subscribe lang po kayo sa channel ko. And until next time, see you all po. Bye-bye!